Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not
We will bring
relevant.
the jury.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican praise service love you.
Is that correct?
Oh, for crumb's sake. I didn't ask you to interrupt me.
Welcome back to the Court of Public Opinion. I am the Recovery Addict. I'm a little small in the corner, but I'm going to fix that. There we go. All right, welcome back. Court has started. It's going on. Where's my phone? Hey Siri, turn on my lights. Don't look at my password. Hang on. Hey Siri, turn on my lights. And make them blue. Hey Siri, make my lights blue. I'm sorry, I should have done this before, but we're jumping. There we go. Now we got blue. Blue on blue. Blue on blue. Welcome back to the Court of Public Opinion. I am the Recovery Addict. Let's see. We have Kim. What is it? What is it when you win 6 times in a row, Kim? What is that? Well, it's what you've done, Kim. Congratulations. You have once again won the internet this morning. With Greeners taken out of competition, you found it very easy to win, but welcome. Let's see. That was as good as a nap in science class when the movie comes on. It was short. Went out to the kitchen. There's no food. We had to go shopping. So I came back and said, I might as well come back live. And guess what? Court's back. So we can do a couple things. We can go back up to Thurston County, Washington, which I'm a fan of because it's starting.
Call up your case here.
Or we could go to Judge Simpson, who's getting a little spicy, but that's landlord-tenant stuff. So
In your case, we don't have service on Mr. Evans or One Main Financial. And do you have anything indicating that they have been served with the small claim?
I have the returned receipts from the certified mail that I sent out. One Main did get it. I spoke to their lawyer Wednesday. But Mr. Gideon Evans, I've sent out 3 since October 10th. I cannot get a hold of him. The bank can't get a hold of him. Nobody can get a hold of him.
Okay. All right. Well, we can't do anything without service. You did list One Main as a defendant. And I don't see that did you send the service proof in? Did they actually sign for the certified mail?
I have, yeah, it's just I have the receipt for it and then a screenshot on the tracking saying that they signed it and received it.
Okay. The problem here is we don't have that. So you need to send it in to us so that I can see that service occurred. So I'm hearing you tell me that. So if you can get that emailed into us, then when I get it, I can award default judgment against One Main Financial.
All right.
But I should ask a question before I do that, which is, what is One Main Financial's connection to your claim for storage fees?
That's the bank that owns the vehicle. That's the legal owner. And they've actually agreed to release their lien if I can get a court order for that today, since they can't get a hold of Gideon either, because he's not paying for the car. It's abandoned at my shop for the last year. So this car is physically in my possession and I can't do anything without it and nobody's paying me. So the next step is to get hopefully awarded this vehicle through a court order.
Okay. So
He just wants the shopping or the parking space.
You run a repair shop. You have
just,
Mr. Evans' vehicle and done work on it or not done work on it?
We have done work on it. Yes.
But he hasn't come to claim it?
It was
He's not.
mistrial.
He's gone. I guess he moved out of the state is what I was told, and left the car with us. He couldn't afford the repairs and can't afford the vehicle, can't pay for the car anyways.
Okay, and what's the total amount of the repairs?
Well, he needs a new engine. That's about $9,000 for the engine, and he couldn't even pay for that.
Okay, I mean, so I'm trying to figure out the nature of the claim. You have a car that you either want to get rid of or...
No, I would like to get paid for the work that's done, and
okay. How did you get the $10,000 of work that's done?
It's actually more than that. His storage fees is 420 days.
Okay,
it's over, and $10,000 is the max that we can claim on small claims. So
right. No, I understand that. Yeah.
Yeah.
Okay, so
I'm over here just trying to get somewhere with this vehicle, and $10,000 or awarded the vehicle so I can recoup some of the funds. It doesn't really matter to me, but this is the only step. This is the process that I got to go through so I can get anything done. I can't get to anybody.
Okay, so listen to the judge's question.
I understand what you're telling me. I'm not sure this is the right process, though. So what you're going to need to do is have Mr. Evans' vehicle declared as abandoned property. And I can't do it pursuant to a small claim. I don't have the ability. Small claim is only for awarding money damages. And if you had service on Mr. Evans, I could award a judgment in your favor for the amount of the work you've done on the vehicle. But you don't have service on Mr. Evans. Service on One Main Financial, I think, you may need to speak to an attorney about this. If One Main Financial is willing to work with you and declare the vehicle as abandoned, then you have an abandoned vehicle if they're the financial owner of the vehicle. But I can't do that by a judgment in this court. The only thing a small claims judgment can do is award money. And without service on Mr. Evans, I can't award a judgment against him. Okay. So you're in right now, unfortunately, this kind of tough spot. You can work with One Main, see what they'll do. You may want to talk to an attorney about how you take care of a vehicle that's been abandoned in your shop, and at what point do you become the owner through, what might be called adverse possession. It actually wouldn't be adverse since he departed, but at some point you should be able to do something with that vehicle.
All right.
So
appreciate it.
That's all I can tell you. So what I'm going to do technically, as far as the small claims go, is dismiss the small claims, because I don't see any basis for going forward on that. I think you're going to have to find a different remedy.
All right. Thank you.
All right. Sorry about that.
All right.
Hey, Ivan, you left my name off the list for some reason. I think it was just a typo. But do have fun. Do have fun on the trip. All right, next up, Judge. Come on. Andale. Arriba.
And pardon me, Ms. Romanello.
This is the lady who said we already went to mediation. It didn't work.
Romanello, good morning again. I think we're in the same spot. Last I looked, you did not have service on Mr. Harrison. Is that correct?
That's correct.
Okay. So you have two options. I can just dismiss the case today, and you can refile it if you ever figure out where he is and can get him served, or we can reset at one time and you can continue to try to get service, but we can't do anything unless he's served with the claim.
Yeah, the thing is that I can't serve him in person, and I ask for a sheriff to, but seems like they don't do that anymore.
Well, they do it, but you have to pay for it.
$35.
Yeah, I asked that today, and they told me they weren't able to do it.
They no longer serve small claims.
Really? Okay, I didn't know that.
They don't do service for small claims?
So what you can do is you can hire a private process server, and you can seek, as part of the small claim, if you hire a process server, you can seek reimbursement for the fees you incur in getting the party served, or you can have an adult not related to you serve them. So do you want to reset it and try to do that?
Yeah, I want to try again.
Okay. All right. So
our next hearing date would be April 24th.
Okay.
24th.
And we'll have to give her a service packet.
We're going to fast forward through this a little bit.
Swear that testimony in this case to be the truth, whole truth, and nothing but the truth.
I do.
Yes.
Maybe seated.
All right, next case. Here we go. So one dismissal, one postponed continuance, and now we get this failed mediation train wreck. What is 3 nautical miles? I've never.
So you went through mediation when you were here back in December?
Yes.
Okay.
Do you have to be a private investigator to do that? Or I'm sure there's like a process server license you need, right? So you know how to do it right.
All right, Ms. Hauger, all I know about the claim is you're claiming $7,000 for property damage. So you want to explain that to me, please?
Yes, Mr. C was a tenant in my condo.
Okay, and before we get going, how do you spell your last name?
S-E-E-S-E.
Okay, S-E-E-S-E. All right. We just had you as C-S-E-E.
Yeah, it's a common problem with people spelling it.
Okay.
I think the name might be
all
a
right.
problem.
So you own the property.
DSN, thank you very much for gifting a membership.
Tenant.
Yes.
Okay.
He was a tenant for several years, and everything was fine. But I decided to sell it. And so I gave him notice, and he asked me if he could stay longer, that he'd pay more rent, and because he didn't want to move in the winter. And I okayed that. And then when March came around, I told him again that I want to sell it. And he begged me again he'd give me more money if he could stay, because he found a place, but it wouldn't be ready until the end of May. So we've always had a good relationship, and I said, okay. And so he moved out on.
This is end of May of what year?
24.
Okay.
Last year.
Last 25, you mean?
Oh, yeah, 25. And so he moved out, and so I had kept in contact with him. We always did emails and or texts, and I said, we need to get together to so you can give me the keys, the garage door opener, and we can look at the apartment. And from then on, he just ghosted me. And so I didn't have the keys, the garage door opener.
Granny got ghosted. Oh no.
Or anything. And this went on for, I don't know, at least 2 weeks.
I like that she knows the term.
So finally, I emailed him and said that because you're not cooperating with me, and I've left phone messages too, that I'm going to have to come to your work and I need the keys and the garage door opener. And he works right across the street from at the coroner's office. And so I went and I was very upset. And he said, well, just a minute, I'll go get your keys. And he went outside to his truck and I waited in the lobby. And then I said, we've got to talk. Because by that time I had used my key and went in and saw my beautiful condo. And I said, I cannot believe that you would leave that condo like that. Unbeknownst to me, he had 2 dogs, big dogs, and a cat. First, the fire door that goes between the house and the garage, that is, everyone has to have a fire door. He decides to put a cat door in the fire door. So now it won't pass inspection because that has to be absolutely a fire door.
You can't get a fire-rated cat door.
And so I had to buy a new fire door and get that all up. And then my hardwood floors were scratched up by the dogs. And in every single living room and all 3 bedrooms had feces and urine from the cats and dogs. And I've got these pictures to show you. And I knew I was going to have, after having a renter in there for several years, I would have to replace the carpet and repaint. So that was fine. But when I took the carpet up, it had damaged the flooring underneath, and the smell, I don't know how anyone lived there. The smell was so bad. And so I had to have somebody come in and use harsh chemicals to sanitize the flooring. Anyway, so I was very upset. I said, we've got to talk. And so he said, okay, well, let's go into this little room. So we went in.
So let's do this. I'm going to try to get you to focus on the legal issues here.
Okay.
Because I know there's a lot going on in the relationship. I can hear that. Pardon me. But my job is to figure out what the legal issue is.
Okay, so
do you have a copy
about the contract?
Do you have a copy of the lease agreement?
I do.
And show it to Mr. C so he knows what I'm looking at.
He probably has it too.
Thank you.
Mm-hmm.
Judy M, member for 27 months. Says, what a way to celebrate 27 months. Woohoo! OG. Cheers to Recovery Addict and the support crew in chat. May your floors never stink and happiness reign. May your floors never stink. I love it. Judy M, thank you very much for your support. 27 months. Wouldn't be the same without you here. Judge is reading through the contract here. It's the lease agreement. Probably a standard lease agreement. It sounds like this woman understands the process and how it needs to be run. She's probably not new to the rental world.
Okay, so what you've given me, Ms. Haver, looks like are two leases, one dated 2013 and the other dated 2021.
Yeah, we did it again.
Okay. So I note in the original lease, there was a security deposit of $500. In the second lease, there was no security deposit listed. I'm assuming that is because you had your $500 from the first lease and you didn't want to add additional security deposit. And I do also see that in the second lease, you added a pet deposit of $100. Correct? Okay. So
when he rented it, he was just renting it by himself. And then I found out he had a pet.
Okay. And you found that out in 2021 when you did the new lease?
Come to find out, he moved a lady in with him, and she brought an old dog and a cat, and I did not know that. So we had a verbal agreement. After I told him that it was such a mess that the contractors told me that it was going to be like $20,000, and I said, well, I'll just take you to small claims court for $10,000. And so he said, after we went back and forth, and anyway, I said, well, what do you want to do? And he offered, after a while, he said, well, would you consider $1,000 a month for the next 10 months? And I thought about it, and I thought, well, that's better than nothing, I guess. So I said yes. Okay. So he paid me for 3 months. And then
And when did this occur?
June, July, and August. He paid $1,000 a month because we had agreed on $10,000. Okay. And he agreed to pay me the first of the month for 10 months. But after 3 months, he stopped.
Okay.
And so that's why my claim is for $7,000.
Okay. And the agreement the two of you had was in writing, or the two of you orally agreed?
Orally agreed. We shook hands on it, and
we spit in our palms and slapped hands, and
we
were blood brothers.
Said, well, I think I better get this in writing. But he wouldn't talk to me anymore. So I had the papers, but he wouldn't, we just couldn't talk.
Okay. All right. Mr. Cease, is that accurate? The two of you have an agreement that you're going to pay a total of $10,000 for the damage?
Yes, sir. She came to my work.
Okay. Yelling. So let me just focus on that. I'll ask the questions since I have a little context here. So two of you had a conversation, sounds like maybe at the end of May, And you agreed to pay $1,000 a month for the next 10 months, of which you paid $3,000?
Yes, sir.
Okay, and what's the story on the remaining balance?
Well, considering the beginning of the conversation that we had, at some point, I just got to the point where I felt like I had been put a position in the beginning that I had no recourse but to agree. She had never showed me any paperwork about the cost of anything, not even when she first came to my work. In September, she sent me a text, said that she had 4 pieces of my mail and that she would be more than happy to give them to me when I gave her the money. My dog passed away and I was extremely distraught, and I know that's neither here nor there because he was a dog. But I just was frustrated to the point where I felt I had been taken advantage of.
Okay. But you acknowledge you agreed to pay $1,000 a month?
Yes.
For 10 months. Okay.
The last, when she told me she wanted to sell, I asked her if she could wait until the end of winter. And she asked me what I was willing to pay. So I told her that I would pay her $2,000 a month. So I did. The last 2 months, when she told me she wanted to sell, again, she asked me what I would be willing to pay because I told her I had a place that I could move into in May, the end of May. And she asked me again what I would be willing to pay. So I figured the only way I was going to be able to make this arrangement was to increase it. So the last 2 months I paid her $2,500 a month. I never was able to use I paid her first and last month's rent. I was never able to use my last month's rent as a fallback. And I also never got notification as to why she was not going to reimburse my original deposit. And from what I understand, it's supposed to be in writing within 30 days of me moving. So I never got that notification either.
Okay.
And some of the damage to the condo, there was a large water stain on the carpet that was from a water leak that happened in 2015 when I was out of state in Ohio. My coworker had gone over to check on the condo. She held her phone up so I could hear the water running from the ceiling. It was coming down from the upstairs bathroom. I gave her the number to Herb Saunders, which is Miss Hogger's significant other. He came over and apparently found a water leak from the upstairs toilet. And that had caused a huge stain on the carpet. Also, the downstairs bathroom, before I moved out, started leaking again. It had leaked prior to me moving in. There was a water stain around the base, and we had discussed that. It started leaking again, so I contacted a plumbing company, to see if they could come over and look at it, and they told me I couldn't make those arrangements, that she had to make those arrangements. So they contacted her, and during that time, it was staining the floor, the hardwood floor. So we shut off the water, put a space heater in. Apparently, what they wanted to charge her was not acceptable. So several days later, Herb came over with a gentleman who's a private contractor, and they looked at it and they replaced the toilet. He even said at the time that the toilet ring was installed wrong, or something was up with the floor that would cause a leak at some point, and it just happened to be leaking at the time when I was ready to move out. She also doesn't discuss the sun damage from coming in the patio door I lived there 11 and a half years, I think. So yes, there were scratches inside the door, and yes, they were from my dogs. I freely admit that. But there was also damage that I did not cause. The
sun
cat
scratched
door,
the floor?
yes, I installed a cat door. It was a standard wooden door in the garage outlet into the garage, so I did do that, yes.
Right. And what were your bills, Ms. Hauger? So
I wasn't
bills
asking
for-
him to do anything.
okay, what was the bills for the replacement of the fire door and the bills for dealing with the flooring?
Okay. I have them here. Let's see.
Have you seen these?
No, sir,
Would
I've
you like
never
to
seen.
would you like to see them?
Well, I tried to.
Oh, okay, no, that's not the point. I just want to make sure that Mr. C sees them. He has the right to see what I'm seeing.
Just give him a second to flip through these as we're trying to catch up to live. Still looking at them. No. Now Judge gets them back. Okay, Judge is reviewing them. See if he's done here. He's taking his time.
However, I'll return these documents to you. Here's your lease agreements and the rest of your bills.
You ready to rule, Judge? Do you want to hear from the defense anymore? The plaintiff? Two times speed would help.
Chase filing fee is 50. Is that right?
That's correct.
And Ms. Hauger, what were your costs of serving the claim on Mr. Cease?
I sent it certified mail
And
with a return request.
okay, it's like
So
$8.50
Yeah.
or something like that. All right. Obviously, a longstanding relationship between the two of you. And Mr. Cease was in the home for a long time. Things happen in homes that aren't the fault of the tenant. The tenant, however, also contributed in this case to some of the issues, specifically the fire door, animal scratches, and damage to the subflooring as a result of urine appearing on the carpet and feces. There were numerous oral agreements between the parties to extend the lease so that Mr. Cease could stay in the condominium until he was able to move into a separate housing. And apart from that was the agreement struck as he departed to pay $1,000 a month. Mr. Cease has argued that he felt like he was coerced to sign that, or not didn't sign it, but to make the agreement. I'm going to find that it was a valid agreement at that time, understanding the damage the unit had sustained, reviewing the various work estimates in there. So I'll find that the agreement to pay the remaining $7,000 or the $10,000, $1,000 per month is an agreement that's enforceable, and I will enforce it. So Mr. Cease, you owe the remaining $7,000 plus $50 service fee and $8.57, or pardon me, $50 filing fee and $8.57 service fee. So we'll give you each a copy of this judgment.
I asked, what about my last month's rent? Will that go forward to that? Because I paid $1,200 moving. I paid $1,200 and the $500.
If you paid for, did you pay for the month of May? Apart from, you said,
yeah,
you
I paid for the month of May.
Okay.
I paid
separately paid for the month of May.
Yes, I paid $2,500.
And when you moved in, you gave Ms. Hauger first and last month's rent. That's what you're talking about. And at that time, the rent was how much?
$1,200.
Okay, so Ms. Hauger, in retaining that, assuming you retained it, you'll have to apply that to the 7,000. That
The 1,200.
yeah, So that'll bring you down to 5,800.
Okay, and what about the $500 deposit that she never notified me in writing why I was
retaining the deposit and the last month's rent, you'll have to apply, so that'll bring it down to 5,300. So that's what you'll need to pay. But the judgment's for 7,000, but you have to apply the money you have, which is 1,700.
Yeah, well.
Okay, just that'll be just letting you know you have to apply that. There's money retained pursuant to the contract. So you can go ahead and give them copies. And you can each have a copy of the judgment. It reflects 7,000 owed, but as we've clarified here on the record, that it actually ended up being 5,300.
The judge just wants to be done with this. He hates this.
Ms. Hauger and Mr. Cease, there you go.
Get up and leave now. You go home now. You've been here for two hours. Next.
Thank you.
So we've gotten a couple DRC agreements.
Okay.
Number 4, community factors. They settled.
Okay.
Somebody settled.
Kaiser persons.
The mediation worked.
Okay.
We have a recap of the smelly condo case.
Yep. Okay. Thank you. All right, folks.
Lady gives the key
Have
to
a
the
nice
house
day.
to this guy.
Thank you.
Stays there for a long time. Money flies away. Then says,
And Ms. Hauger, how do you know Judge Meyer?
Well, I worked for Superior Court for 30 years.
Okay. That's all I need to know.
pay more, pays more, handshake.
Well, I actually.
Then they stops talking to ghosts.
I thought was going to have to go.
She can't believe how bad it is.
Well,
'cause of the
I
dog
just,
and cat poop.
I don't know you personally.
Right.
I think Sam knew
like
you
it.
personally. I didn't. So that's why I could hear it.
Thank you.
You're welcome.
Delinda Foster, member for 21 months. OG.
All right, Jason and Delia Craven, Summerwalk
Thank you very much. Delinda.
Homeowners Association.
This is the lady who rolled her eyes. She did not want to go to mediation.
And it's Ms. Knutson. Are you representing the Homeowners Association today?
Yeah.
She's from
And
the
what's your role with the
HOA.
Homeowners Association?
I'm the association manager.
Okay, if the three of you would raise your right hands for me, please. Swear the testimony in this case be the truth, whole truth, and nothing but the truth. I do.
I do. I do.
Thank you. So this is a claim for $1,726.41. My best understanding of the documents that have been filed was these are homeowners association assessments being withheld by the Cravens, and they want, as I understand it, want judgment that they don't have to pay that. Am I accurate in saying that?
No, Your Honor. We don't have a problem paying the assessments, but we want them to substantiate the charges. We have no idea where our money's going.
Right. So what are you up to date on all your assessments?
No, Your Honor.
Right. So what you're asking me to do is make a ruling that you don't have to pay the assessments until you get a documentation to your satisfaction from the homeowners association. Essentially, that's what you're asking me to do, correct?
I am asking for you to ask them to substantiate the charges. We don't have a problem paying them, but we want them to substantiate the charges.
Okay. So this will go back to the conversation I had at the beginning, which is I can see what the issue is here, but I can't say, okay, this is how we're going to settle it.
Absolutely.
So there's a legal issue here, which is, and I'll go to Ms. Knutson. Ms. Knutson, have you filed a claim against the Cravens for unpaid assessments?
No, we have not. They're asking for the $1,726.41. Approximately $1,100 of that was paid from their mortgage company. I would assume per their request. We did not request that. They do have a balance owing on their account as of today, another $3,173.85. Their last payment they made to the association was December of 21 for $150.
Okay. All right. So I can't make a judgment on a case where the defendant in this case has not sued the Cravens for what the defendant would believe is unpaid assessments. The plaintiffs, the Cravens, are asking me to require the defendants to provide documentation that would support their level of assessments. That's, as you may have heard if you were listening in one of the earlier cases, the only thing we can do in small claims court is to award money judgments. We're not allowed to engage in what's called equity judgments, which is telling people to do certain things. So pursuant to a small claim case, I cannot order Summerwalk Homeowners Association to provide you documentation that would make you feel better about paying your assessments. I cannot, I have no authority to issue that.
Absolutely. I understand, Your Honor.
And there's no counterclaim filed in this case by Summerwalk, so I also can't issue a judgment against the Cravens for the unpaid assessments. So
you're right. Go ahead, Angie. I'm sorry.
So I did provide the Cravens, they requested a records inspection, and I did provide that for a share drive. And we also have a portal with our association where anytime they can go on and they can review any of the financial documents along with their own account balances.
She is right, Your Honor, and it is on there, but the only thing that's on there are summaries. Summaries that even a 14-year-old can generate and say you owe as well. We're looking for them to substantiate the charges. Your Honor, I did understand that you probably could not rule on this case, but I wanted to get to this point because we want to force them to put a lien on our home so we can get in front of a judge that will force them to compel the records. Because to this date,
yeah, I can't force them to put a lien on your home, obviously. So
no, I understand that. It's just part of the legal avenue that we're taking.
Okay. All right. Well, there's no legal basis here for me to take any action on the claim, so all I can do is dismiss the claim. And clearly, the two parties have different views as to the available information. I don't know if you all worked with the mediator and came up with, some discussion about, hey, let's see if we can just provide the information, and does that open paying the assessments. But anyway, I can't do anything about that. So I would just encourage the parties, try to keep it out of court, try to just see if the two parties can work together to meet each of your needs, because I would guess that could happen. All right, folks, I've signed a dismissal on the small claim. Thank you very much.
Thank you.
And they're still negotiating Vargo and Olympia?
Yes,
I will never buy a house with an HOA.
All right. Well, let me know. I'll be in my office.
Sounds good. Sure to let you know.
Okay.
Judge says he's going to step away for a minute. Let's see if he actually has come back already. District Court 2. Oh, 2 is live. Let's go to 2 real quick.
Yes.
Number 7 at 9:30.
State moves to amend the charge to negligent driving in the first degree.
Okay. All right. And on that new negligent driving first degree amended charge.
State also moves to dismiss the driving while license suspended, Your Honor.
Okay, thank you. And on that amended charge, Ms. Haygood, defense okay with waiving arraignment on that?
Your Honor.
Or, I'm sorry, Ms. Myers.
Yes.
Okay, go ahead. All right. So, Mr. Lafferty, what that means is you're now charged with an amended charge of negligent driving in the first degree. That's a simple misdemeanor, punishable by maximum penalties of 90 days jail and a $1,000 fine. Again, I have that plea statement in front of me in which you're agreeing to plead guilty to that charge. Do you feel you've had enough time to go over this document with your lawyer?
Yes, sir.
All right. Paragraph 5 of the plea form outlines certain important constitutional rights that you're agreeing to waive by entering a guilty plea. Do you have any questions about those rights?
No, Your Honor.
And do you understand that an agreed recommendation to a judge, it's just that, it's a recommendation, and the judge does not have to follow it, but could sentence you up to the maximum penalties I just went over a moment ago? And if so, that's not a basis for withdrawing your guilty plea. Do you have any questions about that?
No, sir.
Okay. And let's see, the agreed recommendation being made to the court is, as the prosecutor already went through, to amend the DUI count 1 to negligent driving in the first degree, and to dismiss count 2, driving with a suspended license in the third degree. All right, and then impose 90 days jail, but suspend all 90 for a period of 2 years. And while on probation for those 2 years, there's certain affirmative conditions and certain other, we call them passive conditions that would go over at sentencing. Generally, sir, is that your understanding of the agreed recommendation?
Yes, sir.
All right. And I see the box here has been checked that if you've been advised that if you are not a U.S. citizen, guilty plea to a criminal charge may carry adverse immigration consequences. Do you have any questions about that?
No, sir.
All right. I see the box has also been checked that you've been advised that even though you are pleading to an amended charge that's not a DUI, because it's amended from a DUI, this conviction will be seen as treated as a prior offense for certain pretrial release conditions and sentencing enhancements. Should you be charged and convicted of a DUI, a physical control, or similar offenses within a 7-year period? Do you have any questions about that?
No, sir.
Has anyone made any threats or promises to get you to change your plea today?
No, sir.
Paragraph 11 of the plea form provides for a statement of fact used to support that change of plea. I'm going to read it to you and ask you if it's accurate. And that reads that on August 21st, 2023 in Thurston County, I drove a car in a way that was negligent and posed a risk to public safety while showing signs of having consumed an intoxicating substance. Is that an accurate statement in your own words?
Yes, sir.
All right. Well, Mr. Lafferty, to that charge of negligent driving in the first degree, how do you plead, guilty or not guilty?
Guilty.
All right. I find Mr. Lafferty's plea of guilty to be knowingly, intelligently, and voluntarily made with an understanding of the charge and consequences of the plea. And there's a factual basis supporting the plea. All right. So what I'm going to do next, sir, is sign the plea form, and then I'm going to turn it over to the attorneys to talk about that agreed recommendation. Then you'll have the chance to address the court before imposing sentence. You don't have to say anything if you don't want to, but you'll have that opportunity. All right.
Okay.
Start with the prosecutor, Mr. Lindgren.
State asked the court to follow the agreed recommendation, Your Honor. It was well negotiated between the parties.
Okay. Thank you.
And Ms. Myers?
Thank you, Your Honor. I am standing in for Ms. Moore. She is present on Zoom, but bless her heart, she probably should just be resting anyways.
I got that impression.
I spoke to her, and Ms. Moore said that Mr. Lafferty has been a great client to work with. When this case happened, he was only, I don't even know if he was 19 at the time. He's been out of trouble since then. There's no doubt in Ms. Moore's mind that this is a one-time incident. We won't be seeing from him again. As to date, he has everything taken care of with the Department of Licensing. His license should be good. I know that there was some kind of trouble there, but he's taken care of it. He has a great job that he works graveyard shift. So I think that as far as his run-ins with the law, this will be the last that we will see from Mr. Lafferty. We would ask you to follow the agreed recommendation. We would also ask that you waive any fines and fees if possible.
Okay. Ms. Myers. And any pretrial affirmatives done? Be aware of? I'm not seeing any in the file, but.
Your Honor, I am not aware at this point.
All right. Mr. Lafferty, this is your chance to address the court. Again, you don't have to say anything if you don't want to, but floor is yours if you do.
I don't have anything further to say, Your Honor.
All right. Thank you, sir. Well, it sounds like Ms. Moore, your attorney, negotiated well on your behalf, and Ms. Myers representing you today. So I will go ahead and follow this agreed recommendation. So the state has moved to dismiss that driving with a suspended license charge. So that's dismissed. On that amended negligent driving in the first degree conviction, I'll impose 90 days, suspend 90, following the agreed recommendation. That will be for a period of 2 years. So you'll be on probation through February 21, 2028. During that period of time, you've got some conditions of probation, which include to not commit a criminal offense, to not consume any alcohol, marijuana, or non-prescribed drugs, to not go to any bars or taverns, to not drive without a valid license or insurance. According to your driving abstract, looks like you got relicensed, so well done there.
Thank you.
To not refuse a UA or a breath test when requested by law enforcement. And I believe since this is you don't have a prior offense within the period of 7 years, there shouldn't be any ignition interlock device requirements from the Department of Licensing. All right, so those are all sort of we call them passive conditions. So things you don't do. You've got some affirmative conditions as well. And those include to get a substance use evaluation and comply with whatever the recommended treatment program is. So it's important to remember it's not just getting that evaluation, but it's also then understanding what the recommended treatment program is, and then following through with that. Those recommendations sort of automatically become your conditions of probation. And then also doing a DUI victim impact panel. We're going to set not another court date, but what we call a proof by date, where someone from the probation department is going to check your file, make sure that that's been done. And if it hasn't, then we set a compliance review hearing and haul you back into court. So hopefully there's no need to do that. Let's see, we'll go out, give you 60 days. Go out to Friday, April 24th. So by Friday, April 24th, court's going to want to see a copy of the substance use evaluation, victim impact panel completion certificate, and if there is a treatment program recommended, hopefully some compliance reports by then. Because you've got some affirmative conditions related to treatment, court is going to put you on active supervised probation. So you'll need to contact a probation officer within 48 hours. The judgment and sentence form, which you can get from the public defender's office or off the Thurston County District Court website, has the phone number for probation. What they're going to do is set up a time for you to meet and go over those treatment requirements for you and sort of the things you have to do while on probation. They're there to be a resource, help you stay in compliance. If it looks like you're, based on your history, my hope is that there aren't any issues there, but they're intended to kind of help you maintain compliance. So if you're in treatment, everything's going well, you're knocking out your affirmatives, they can kind of move you off of that active supervised probation supervision intensity down to monitored, but that's sort of their call at that point. Because you are going to be on active supervised probation, though, there is a probation fee. You have the 2 years to pay that off, though, and that's going to be $120. But again, you got the 2 years to pay that off. If you want to work out a payment agreement, you can call Thurston County District Court, and they can work out a time payment agreement with you.
Okay.
All right. Any questions, sir?
No, sir.
All right. Well, good luck to you. Again, I've got the judgment and sentence with all of this information will be available. You can get it from the public defenders again, or from the district court website. And I wish you luck.
Okay. Thank you so much.
Good luck and good riddance.
Have a good rest of your day.
You too. Bye.
Let's see. Courtroom 3 is not back yet. So we're just waiting for the next.
Back to you, Ms. Hagan.
Thank you, Anna. Next, I'll be calling Mr. Pennypacker's case, number 3 on the 8:30 calendar. I believe the state is moving to dismiss.
Okay. State moves to dismiss Mr. Pennypacker's case, Your Honor.
Thanks, Mr. Lindgren. All right.
Lindgren.
So with Mr. Pennypacker.
Is that Ms. Rowe? It is Ms. Rowe. How are you doing? Yeah.
Ms. Hagood, you can let your client know if he wants a copy of this judgment sentence. It'll be available on the website, or I suppose through your office. Nothing he needs to do with it, though. Any active orders? No. Okay. Nothing to rescind.
Ivy Brilliant, good luck with your new sourdough. Sounds amazing.
Yes, Your Honor. If we could call the Corbin Welch matter. Mr. Corbin is present on Zoom.
Okay. Morning, Mr. Welch.
Morning. Your Honor, Mr. Welch and I have exchanged phone numbers now. We are asking the court to proceed to the April 3rd court date at 10:30.
Mr. Welch, as Ms. Rowe there indicated, we've got trial confirmation on April 3rd at 10:30. So we're just going to keep that date for now. Are you getting mailed notice and text reminders of your court date?
Mailed notice.
Mailed notice? All right. Yeah, it seems our text reminder system is not operating correctly. Can we just double check his number? Yeah. All right, we're gonna just double check your number. But if you are getting mailed notice, that's good to know. And it sounds like you've got Ms. Rowe's contact information too.
Mr. Welch's number ends in 1244 if the court wants to compare that against the number it has.
Oh, he's last.
1244.
What? 1244. Okay, we're gonna check here. Yep. So, all right. You gave the correct number. The issue's on our end, Mr. Welch. But sounds like you've got your court date. You're in good contact with your attorney, so we'll see you back at trial confirmation.
Thank you, Your Honor.
All right. Thank you, sir. You're free to go.
Right. Bye.
Your Honor, I'd like to address the last case that I have. It's the Broussard matter, which is number 1 and 2 on the 10 o'clock calendar.
Okay.
I have unfortunately lost contact with Mr. Broussard, which is very rare. So I don't have any representations to make to the court. I would ask the court to strike the jury panel set for the 2nd and the 3rd. My request would be that the court reset confirmation and jury trial dates without issuing a warrant, just noting the FTA. I realize the state may have a different request, but that would be my request. Mr. Broussard is generally very good at appearing for hearings and keeping in contact with me.
Thank you, Ms. Rowe. Let's see. Go ahead, Mr. Lindgren.
The state does request a bench warrant, Your Honor. This is Mr. Broussard. This would be his second FTA in this case, albeit the first one it looks like happened back at arraignment. However, I mean, it is an ignition interlock. It's not his first time that he's been here on this charge. The state thinks a warrant would be appropriate. Also, noting that this is confirmation.
It looks like he's been here before recently. I just want to make, I see a Superior Court matter resolved recently. I just want to make sure he's not in DOC custody. Is that right? I think he appeared in December. Okay.
That was the last time he appeared.
Okay. All right. That was after his change of plea in Superior Court. Okay. I just wanted to make sure we weren't missing him because he was incarcerated somewhere.
Someone needs to give somebody a new mouse with a quieter scroll wheel, because that is so loud.
All right, Ms. Rowe, your request again, it was to set new dates
and FTA and reset confirmation and jury trial dates out to give me a chance to try to track him down.
I think it's the judges.
Could we well, let's do this. Let's rather than reset dates in the hope that he's got, I'm not going to issue a warrant today just based on the nature of the offenses here. But I will note the FTA. Let's leave the trial dates and then we'll just strike the panel. And hopefully appears on the 4th. And then if not, we can address it then.
How do you leave the trial dates and strike the jury panel?
Understood, Your Honor.
It's a jury trial.
All right. Thanks, Ms. Rowe. And
I believe that's all I have this morning.
Okay. Thank you, Ms. Rowe. Have a good weekend.
Thank you.
Still waiting for small claims court to come back.
Go ahead. You can do it, and then I'll sign this. Okay, thank you.
And then folks can just let me know if we've got any more 3-4 appearances. And if not, I can start running through failure to appears.
Yes, Your Honor. Give me 1 second. I'll be calling Miss Susan McNeil's matters, numbers 7 and 8 on the 9 a.m. calendar.
9 a.m. They're way behind.
Susan McNeil.
I'll be covering for Miss Moore in this matter. Miss McNeil called our office to have her appearance waived today, but Miss Moore was unable to reach back out to her to figure out where to go from there. So we are asking the court to waive her appearance under Rule 3.4 and to keep the trial dates to give Miss Moore enough time to consult with Miss McNeil. And strike the panel. My apologies.
Thank you. And is this a case you'll be taken over from Ms. Moore?
Unclear.
Okay. And I'm sorry, I was looking through the docket too while you were addressing the court. My apologies. Was the request to reset dates or to keep the dates?
We'll keep the dates, strike the panel.
Got it. Thank you. Appreciate that. For both matters?
Yes, Your Honor.
All right, we will do that.
I'm looking for the question here. Did you tag me in the question?
And back to you, Ms. Haygood.
I believe we have one last matter.
Jesse Eubanks.
Yes.
Go ahead.
No representations.
Looks like Mr. Eubanks
Monday
was here at the last hearing.
Monday's
Notice
court
handed.
is 8:30 Mountain Time start, which would be
Custody
a 10:30 Pacific time or 10:30 Eastern Time start. They're 2 hours behind us. We're probably going to go live probably an hour before. It's like 45 minutes, an hour, 45 minutes before court starts. I'm waiting right now for some updates from my contact there in the Summit County Court system, just to get everything lined up. We're
like there's been
supposed to be doing it this afternoon.
All right. And looks like summons has not been returned. Court will issue a bench warrant in the amount of the amount has ratcheted up over time.
You can't say the word ratchet in court, Judge.
Stay consistent with the last warrant amount, $2,500. Let's see. Next FTA I have here, Michael Dement, 3 at 10.
This looks like it's a private attorney, it's Attorney Avery.
Yeah.
I've also not seen her logged on today.
I believe might be in custody. Yes. Is he on the 130?
While the judge is sorting that out, I'm going to mute him for just a minute. Still waiting to see if we get any more small claims action from Thurston. They only get 1 hour. 1 hour, I believe a month, dedicated to small claims courts. This is how much Thurston County hates small claims court. And whatever they hear in that time is fine. Everything else gets pushed. And so it really does drive people to mediation and sort out their issues either through crime or through mediation. Crime being the preferred method, apparently, in the area. So, but the courts does not like deciding whose money belongs to who. Let me give you a little update from our friends down in Tucson, in Arizona, in the Nancy Guthrie case. The love affair between the media and the sheriff's office has come to an end. The sheriff's office is now not letting the media in the building anymore, unless it's to use the bathroom, and that is all. And don't abuse the privilege. You have to use the call box to get in and beg every time to use the bathroom. And if you abuse the call box, then you'll be asked to leave and don't get to use the bathroom there at all. This came in the form of an email update to all media personnel who have registered with Tucson County, including myself. In addition, the sheriff is not doing any more one-on-one interviews today, tomorrow, or any time over the weekend, so please stop asking. That is the update. So there you have it. And of course, the media is at war with themselves as well, both the traditional media and the new media, being the YouTubers. YouTubers were getting more views than the established media, and they were also getting more content than the established media. And so there's a little bit of a back and forth, little arguments back and forth. They're obviously jostling for the same space outside of Nancy Guthrie's house, and the YouTubers who live in their car are able to stay there 24/7, and the news TV crews have to pack up and go home back to the hotel or to either live shot or something. So Brian Enton will get a Pulitzer for his work. Mark my words, he should. There have been hit pieces. The traditional media have been putting out snide remarks and comments regarding the YouTubers there and how little regard they have for them. And it's just turning into a whole show, as Kurt would say, a whole show down there. Side Edition's not happy with the YouTubers. There's another option: hire the YouTubers. Yes, buy your competition. That's the way the business goes. But I love it. I love it, and I love it for the same reason that we got involved in the Cavalcante chase. We have a situation where information from the authorities is not forthcoming. Nobody trusts the authorities, and by nobody, I include the kidnapper. They won't even send messages to the police. They're all going to the media and TMZ and these. It is wild. But basically, the sheriff is trying to hold all the cards and hold them closely and not to reveal anything, even to the FBI. The FBI wants to help, but won't step on anyone's toes. Has to be asked to help, and it's a circus. And so when there's no information coming out, it makes the environment ripe for individuals on the ground with the phone and the will to go and just ask people questions. They can thrive in that environment, as you've seen people like Brian Enton and some of the others do. There are quite a few, 7, 8, 9, 10, I don't know how many different channels down there, and some of them are polling 20 to 100,000 views at a time as they're going live to let people know what the real update is from the ground. So I'm all there for it. I think it's amazing. I do think that as in this new world of media, we have to work together a little bit. So we need to find a way forward so we don't just eat each other, because that's not productive. But anyway, that's the update. The sheriff doesn't like media. Please stop using our bathroom, they say. You should bring your own bathroom. All right, with that, Thurston County looks like they're done. I think we've hit the time limit. We're after the 12 o'clock hour for them. I believe we only had 1 hour for court, for small claims court. I told you we're only going to hear 2 cases, and I think that was right. Let's see, we do have Judge Simpson. He's currently private right now, so nothing going on there. Let's see if we have anybody else. The OnlyFans girl showed up in court and was blowing kisses and sticking out her tongue and flirting or smiling and joking with somebody in the audience. So that was interesting. Let's see, Georgia State Expedited Calendar is up. Let's see who else we have. Click, 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 click. I think we're about done. It's a Friday afternoon and it's getting really quiet in the court world. Judge McBurney might have a jail Zoom. Let's check this one out.
Un curso con respecto a el manejo del enojo.
And lastly, that the defendant be banned from Fulton County.
Y por último, de que el acusado se permanecerá alejado del condado de Fulton.
The state did get an opportunity to speak with the victim in this case.
La Fiscalía Estatal tuvo la oportunidad de hablar con la víctima en este caso.
This is Ms. Lowe?
Yes.
¿Esa es la señora Lowe? Sí.
She informed us that she has forgiven the defendant.
Ella nos informó de que ella ha perdonado al acusado.
That she believes in second chances.
De que ella cree que hay segundas oportunidades.
And that she just wishes for no contact with the defendant.
Y de que ella desea no tener contacto con el acusado.
And what is their connection? Strangers?
Strangers. She
¿Y
is
cuál es su conexión? Son desconocidos.
she is the manager of the building that the defendant was at the time of his arrest.
Okay.
Ella es la manager del edificio ante el cual el acusado estaba presente en ese entonces.
And that is all from the state, Your Honor.
Y señores, esto por parte de la Fiscalía Estatal.
Thank you. I believe we have someone, yes, Officer Stallworth from pretrial.
Hang on.
Ya, me parece que tenemos al oficial Starworth del Departamento de Servicios Previos a un Juicio.
Yes, he has 20 cycles.
20?
Así es, él tiene 20 ciclos.
10 out of the state of Florida, 1 out of the state of Louisiana, 1 out of Mississippi, and 3 out of Texas, 2 out of Puerto Rico. I'm sorry, you need me to start?
An interpreter requests that the previous statement please be repeated and broken down into smaller chunks.
Yes, sorry. The first 10 cycles were Florida.
He's an amateur.
El intérprete ha pedido que se repita la oración previa. Ha indicado de que tiene 10 ciclos del estado de Florida.
1 out of Louisiana.
1 de Luisiana.
1 out of Mississippi.
1 de Mississippi.
3 out of Texas.
3 de Texas.
2 out of Puerto Rico.
2 de Puerto Rico.
There's a 2018 conviction.
Hubo una condena en el 2018.
Out of Orange County, Florida.
Del condado de Orange en la Florida.
For possession of cocaine.
Por posesión de cocaína.
There's an active warrant.
Tiene una orden de arresto que está activa.
Out of Fulton for FTA.
Del condado de Fulton por no comparecer a una audiencia.
Date of that warrant.
La fecha de esa orden de arresto
is April the 25th of 2025.
Es el 25 de abril de 2025.
There is a conviction outside of the 10-year period.
That's okay. I'm good with what you shared. Thank you.
Okay. You're welcome.
Hay una condena más allá de los plazos de 10 años y el juez indica que está bien. ¿No se necesita eso? Gracias.
Ms. Wood.
Señora Wood.
Thank you, Judge. Mr. Rivera has no ties anymore to Georgia or Fulton County.
Gracias, juez. El señor Rivera ya no tiene ningún lazo con lo que respecta a Georgia o al condado de Fulton.
He lives in southern Mississippi with his wife, Melissa, who is actually on this call.
Él, de hecho, vive en la parte sur de Mississippi con su esposa, quien, de hecho, está en esta llamada.
And so as part of our negotiations, we just wanted to make sure that everyone understood that he has no reason to be back in Georgia after he's resolved this case.
Y pues eso es parte de nuestra negociación. Y nosotros queríamos hacerles saber de que una vez que este caso quede resuelto, él ya no tiene nada que lo ligue al estado de Georgia.
Ms. Wood, is it your experience with misdemeanor probation?
Y señor Wood, ¿es su experiencia con lo que respecta a aprobación, con lo que respecta a delitos menores?
That they will supervise people virtually out of state?
¿De que ellos supervisarán a gente fuera del estado?
Yes, Judge. However, I'm glad you brought that up because
Sí, juez, y gracias. Me alegra de que usted lo ha mencionado.
right before the call, I remembered that there could be an issue with JCS, which is the misdemeanor probation folks.
De que pues sí, de hecho me acordé justo antes de esta llamada de que quizás surja alguna cuestión con lo que respecta al departamento de probaciones con lo que respecta a delitos menores.
With supervising a Spanish-speaking client.
Con el supervisar a un cliente de habla hispana.
I did share that information with Ms. Smith.
Y compartí esa información con la señora Smith.
And I reached out to them, but I haven't received an email back yet.
Y yo me he puesto en contacto con ellos, pero ellos no me han regresado el correo electrónico.
So with that being said, I am asking the court to perhaps suspend the sentence.
Y habiéndose dicho eso, pues me gustaría pedir a la corte que quizás suspenda la condena.
He has served actually 196 days for this case.
Y de hecho, él ya ha servido 196 días con lo que respecta a este caso.
It's 3 separate booking numbers, and I sent those to Miss Nelson. I can put those on the record if needed.
I have the same math you do. I've already found those dates.
Y pues de hecho son 3 diferentes números de orden de arresto. El juez indica de que sí, él tiene las mismas fechas y las mismas cifras y ya cuadrado las cifras.
So that's our request, Judge. I appreciate Ms. Smith working with us on this one. Mr. Rivera is eager to get out of Georgia and back to Mississippi.
Y su señoría, ese es nuestro pedimento, es el acuerdo que nosotros hemos llegado a tener con la señora Smith, y el señor Rivera está ansioso por salirse de Georgia e irse a Mississippi.
Mr. Rivera, do you have any questions?
Señor Rivera, ¿tiene usted alguna pregunta?
No, sir.
No, sir.
Why are we using a translator?
I find there's a factual basis for your plea.
Yo veo de que hay hechos ante los cuales usted se ha declarado.
And that your plea is knowing and voluntary.
Y de que usted se ha declarado con conocimiento y voluntariamente.
Which means you've understood what we've said.
Lo cual quiere decir de que usted ha entendido lo que hemos dicho.
And no one is forcing you to enter this plea.
Y de que nadie le está forzando a que se declare de esta forma.
Do you agree with that?
¿Usted está de acuerdo con esto?
Sí, señor.
Yes, sir.
Ms. Wood, can someone in my office sign the indictment for you?
Señor Wood, ¿acaso hay alguien en mi oficina que podría firmarle por usted?
Yes, Judge.
Ms. Smith, same question?
Yes, Judge.
Se le hace la misma pregunta a la abogada Smith, indica que sí.
And Mr. Rivera, can someone in my office sign the indictment for you?
Y señor Rivera, ¿acaso alguien en mi oficina podría firmar su nombre?
Sí.
Yes.
Mr. Rivera, I'm going to sentence you on count 1 to 6 months in custody.
Señor Rivera, yo le condenaré a usted con respecto a la acusación número 1 a servir 6 meses de encarcelamiento.
Count 2 will be 1 year, will be 12 months.
Y con respecto a la acusación sería 1 año, no, disculpe, 12 meses.
Count 3 will be 12 months.
La acusación número 3 también será 12 meses.
Those will run consecutive to each other.
Y esos se llevarán a cabo consecutivamente uno con el otro.
And to count 1.
Y con la acusación número 1.
So it's a total sentence of 30 months.
Y es una condena total de 30 meses.
6 months in custody.
6 meses de encarcelamiento.
And 24 months.
Y 24 meses.
Suspended.
Suspendidos.
There are 2 conditions of your suspended sentence.
Hay 2 condiciones de su condena suspendida.
Number 1 is no contact with Ms. Lowe.
Número 1 es que no tendrá contacto con la señora Lowe.
He's not talking about
Number
the lawyer.
2 is that you are banished from the state of Georgia.
Y número 2 es de que usted permanecerá eliminado del condado de Georgia.
With the exception of the Waycross Judicial Circuit.
Con excepción del circuito judicial de Waycross.
So basically you need to stay out of Georgia, but if you really need to come to Georgia, you can only go to that circuit.
Y pues básicamente usted tendrá que mantenerse alejado del estado de Georgia. Pero en dado caso de que usted realmente tenga que venir a Georgia, solamente podrá ir a ese circuito.
Do you understand that?
¿Entiende usted eso?
Sí, señor.
Ms. Wood, Ms. Wood, anything else on behalf of Mr. Rivera?
Señora Wood, ¿algo más a favor del señor Rivera?
No, Your Honor, thank you.
Ms. Smith, anything else on behalf of the state?
No, Judge.
Indicó la abogada Wood que no. Señoría, se le hizo la misma pregunta a la abogada Smith, también indicó que no.
Mr. Rivera, you should be released early next week. I will sign the paperwork today, but it may take over the weekend for it to be processed.
Y señor Rivera, yo firmaré el papeleo el día de hoy, pero pues puede que se tarde todo el fin de semana, a modo de que probablemente le darán a usted en libertad a principios de la próxima semana.
When you are released, you need to leave Georgia. Do you understand that?
Cuando se le ponga a usted en libertad, usted tiene que salirse del estado de Georgia. ¿Entiende eso?
Sí.
Yes.
How are you getting home?
¿Cómo es que regresará a casa?
En Greenhouse Bus o mi novia me viene a buscar.
Either a Greyhound bus or my girlfriend's going to come get me.
Sounds like a plan.
Parece que ya tiene un plan.
Good luck.
Buena suerte.
Gracias.
Thank you.
We need to do Mr. Reeves next. He is in medical, and I've been asked to do that next. I don't know what.
Do we need that sound
there's
bite?
something called medical.
You were banished, you're banished from the
Been
state of
asking
Georgia.
around, where the heck is medical?
I've heard of stay out of Fulton County, but
And it's right there.
you're banished from the state
Let
of
me.
Georgia.
Oh, and someone just unmuted it. Fantastic.
Judge
Let's get
McBurney's
Mr.
audio's
Reeves,
gotten
Ms.
a lot
Rios,
better.
that is you.
It's still overmodulated, but
Yes, Your Honor.
I think we need a
Let's
Georgia
add
sound.
you. Okay. What are we doing today with Mr. Reeves? He missed court. This is a older case, and he's now in custody, picked up on a bench warrant.
Your Honor, I did file a motion to set aside the bench warrant. My investigator went to go talk to him to find out what happened. I didn't file a waiver because I wasn't sure if he wanted me to stay on his case because he let her know that he would possibly be hiring a private attorney. So I'm not sure if that's still the case.
Okay. Well, let me start by then asking you, Mr. Reeves, tell me what your plan is. Are you planning on hiring a lawyer?
Yes, sir. I'm planning on hiring a lawyer after, depending on how my surgery go. I have surgery with my broken neck and my leg, so I don't know how long that's gonna take me, but I know it's gonna be 6 months to a year of bed rest before after I do surgery to heal, and then I got physical therapy to teach me how to walk again. So I plan on hiring an attorney and fight the case.
Where, just so I can understand, oh, there's someone in court for you. Who's here?
That's my fiance.
Fiance is here. Okay. She may be able to help me understand. It sounds like you're going to be out of commission for a while, which probably means you're not working, which makes me think, how are you going to hire an attorney? Please, hold on, Mr. Reeves.
I'm sorry.
So, he had a injury at work, so he has like work stuff going on right now.
Okay.
The reason he missed the court date is because we ended up moving and we never got the new court date.
Okay.
We did not notify anyone, but we never received the court date. That's why he didn't go.
We moved and then we didn't get notified.
His things and make sure he gets to court and stuff and his doctor's appointments. But
So I have two different addresses in the system. One is from Fairbanks.
so we currently live in Douglas. To Douglasville when I was pregnant, November 2023.
Okay. Sutton Place.
That's where we live now. That's where we've been.
Got it. But he at least used to be at Smoke Ridge Drive in Fairburn.
Yes, that's where we used to live together.
Okay. And you moved together to the Douglasville address.
Yes.
Are you working?
Yes.
What do you do?
I work for Toyota.
Okay. So you have an income and Mr. Reeves has workers' comp. So there's money coming in. And Mr. Reeves, it is your desire to hire an attorney?
If I haven't talked to her, it seems like she's pretty good. If me and her can just talk to each other personal, and she can speak to me, like I really don't know how the case is going because it's so long, but I don't mind hiring her if I can.
Well, unfortunately, she's not for sale. But it also would be a question of whether you financially qualify. If you're getting workers' comp, my guess is you do qualify, but I don't mean to speak for Ms. Rios and her office. So it may make sense to have Ms. Rios have a consultation with you. I think for right now, I'm going to have Ms. Rios represent you just for the narrow purpose of working through whether we set aside this warrant. Do you have surgery already scheduled, or you're hoping to have surgery scheduled?
Yes, sir. On the second, I go get a CT scan and an MRI to see how they're gonna go into my neck and my leg. And yes, they're supposed to be on the 25th of March.
Okay. So it is scheduled. They're just going to do another check through the CT scan or MRI or both.
Yes, sir, because with my neck injury, it's a 50-50 chance that if it be a mistake, it could paralyze me. So this doctor is the fifth doctor that we're going to. The other doctors don't want to take the chance. So this Mr. Barber, he think he can go ahead on and take the chance and get me taken care of with all three of my injuries.
What was your job where this happened? Were you like a stunt guy?
I'm sorry. No, sir, I'm a commercial electrician, and what happened, I was on a ladder at 13 feet, and the guy who worked the night before installed the camera, and when I got ready to hook it up, he did not secure it correctly, and it fell on my head and knocked me out, and I fell 13 feet unconscious off the ladder.
Okay, that's never a good plan. I'm sorry that happened. Okay, and I'm looking at the case here. We're dealing with an allegation from February of 21. So we're now at the 5-year mark. Let me hear from the prosecutor to see if she's got a perspective on whether I should set aside the bench warrant now that we've got a good address, your fiance has shown up, and you've got this pending medical appointment. Ms. Smith?
Yes, Your Honor. At this time, the state doesn't oppose to setting aside the bench warrant.
Okay. Me neither. So your bond is from April of 2023. And I guess I'll just reinstate that bond. Hold on. Okay. Close that. The main condition was to stay away from Mr. Waddell, that's the alleged victim in the case, and to stay away from an address in Hapeville. Sounds like both those should be pretty easy if you're living out in Douglasville now. Does that still make sense?
Yes, sir, especially when I'm going to be laying in the bed for the next year.
Right. Let me ask about that, because what we're probably not going to do is leave you alone for a whole year. Are the doctors saying that, like, literally you can't sit up for a year, or you just shouldn't go climb a ladder and have a camera fall on your head?
I'm sorry. Basically, when they go into my neck, it's my leg. Once they do my leg, I know my leg gonna take 6 months to heal, because I ripped my ACL, my MCL, and my every ligament in my knee. It's gonna take just 6 months for that to heal. And for as my neck, they gotta go into the top of my neck and also the lower part of my neck. So they're probably gonna have to put a body brace on me, and that's what the last doctor said. So I haven't talked to Mr. Barber. He haven't told me what he's gonna do, but they basically told me I need to prepare for at least a year of bedtime, just to heal and learn me how to walk again.
Okay, that's a long time. Got it. Well, we'll figure out a way to move your case along. It may be that you appear virtually for things. You may appreciate breaking up the monotony of just laying there in bed.
I'm in a wheelchair right now, so I'm tired of the wheelchair. Oh, God.
Okay, well, that'll be a switch from wheelchair to bed.
And not a good
all right. Ms. Smith, anything else on Mr. Reeves' case?
No, Your Honor.
Ms. Rios, how do you want to do this? Right now, you have helped Mr. Reeves by getting the bench warrant set aside, but I guess you and he need to have a conversation about representation.
Yes, it seems like he'd be happy to have me. So I think that will be, and I don't mind staying on the case. If he's not working, I'm sure he would qualify. But I do need a contact information, because I want to be able to keep in touch with him about the case. Is there any way, I don't know what the best way to do that. Can someone type it in the chat? I don't know. I don't really want to broadcast his number on the internet.
How about this? I'm going to have his fiance write down, Deputy Gordon's going to give her a note card, and she's going to write down any phone numbers for herself or for Mr. Reeves, the home address, email, and then I'll get that to you, Ms. Rios.
Thank you.
And then once you've had a chance to consult, once you file an entry and a waiver of arraignment, we can get the case moving along.
Okay, sounds good.
All right, Mr. Reeves, any questions?
No, sir, and I would like to keep her as my lawyer if she'll accept me.
Okay, well, she's gonna have to think about that one, but if she says yes, then you're in luck. So I don't know when I'll see you next. If it's not before your surgery, good luck with everything.
Okay, so I can go home to my little girl?
Well, you didn't tell me you had a little girl unless that's how you're referring to your fiance.
No, sir, I got a 2-year-old little girl that I keep telling, she's missing me and I keep telling them at work, so.
Got it. Nope, you're not gonna be at work much longer. I'll sign some paperwork today. I cannot promise you that you'll get out before Monday. It may be Monday when they release you, okay? All right, but then you can go home and be with your little girl and your big girl, and you need to stay out of trouble while you're on bond, okay?
I absolutely will. I give you my word.
Okay, all right. Good luck with things.
Thank you.
And thank you, medical ward.
No problem. Thank you.
Okay, this is a crazy one. Are you done, Judge? I don't know if he's gone or not. We'll hold tight for a second.
Okay, we're gonna do your other case.
Okay, so
You're leaving.
Amy here will replace me because I have to be at the jail.
Okay, that's fine. We're gonna do, it's up to you. It's gonna take 2 minutes. The only other thing we're doing is if you need to do the handoff, do the handoff.
I'll do the handoff. Yes.
It's position 7. Oh, you don't have the calendar. 2 North, booth 1. Is it, well, hold on, is it legible?
Yeah.
Okay, I just want to make sure we can read it.
Yeah.
All right, good luck with things.
Yes. So San Gampa, miro Tipping Tom. No sé.
Did he say?
Ooh,
peeping
look at
Tom?
that. Yeah,
Okay.
thanks.
All right, and also time.
Come on up.
Thank you.
All right.
The red X, please.
Thank you.
Hey, Josh.
Are you Senor Gamba Mateus?
Yes, sir.
Excellent.
Yeah,
You're up.
excellent, dude.
Where do we need to stand?
Where he was seated, just at defense counsel table, just taking that seat.
And whenever you're ready, I just need a second to introduce myself to Mr. Gamba.
Why don't you do that? He's on the screen. So you just take a seat where he was. And then when you see yourself on the screen, you're in a good spot and you'll see your client on the screen. There you are.
Okay. Buenas tardes. Señor Gamba, ¿me escucha?
Sí, señora, buenas tardes, tengan todos. Dios los bendiga.
¿Me entiende bien?
Súper bien.
Entiende que yo soy la intérprete, voy a repetir todo, no soy su abogada, ¿correcto?
Ok. Sí, señora, muchas gracias.
He can hear me, he can understand me, and he knows I'm going to repeat everything he says and I'm not his attorney.
Thank you for doing that.
Tengan buena tarde todos. Dios los bendiga.
¿Cómo?
Tengan buena tarde todos. Dios los bendiga.
Hey,
Good
Josh, if you
afternoon
can
to everyone.
just put an
Good
exclamation
afternoon,
point
Senor Gamba
in your
Mateus.
state code
Buenas
in
tardes,
chat, that
señor
would be
Gamba
great.
Mateo.
I'm Judge McBurney, and we are going to talk about bond in your case.
Yo soy el juez McBurney y vamos a hablar en su caso acerca de una fianza.
This is 25
Exclamation point
SC
and then your state code,
005757.
Entonces, ese es el caso 25 SC 005757.
Mr. Gamba Mateus, you are banished from the state of Georgia.
El señor Sebastián Gama Mateo lo está representando
there you
la
go,
abogada.
that's
You
just
are
read.
banished from the The state is of represented Georgia by Ms. Smith.
Y por
Apparently need a
ahora, por
timeout
la
time around
audiencia
that
de hoy, la señora Smith
You are
está de la
banished
Fiscalía
from the
representando
state
al
of
Estado.
Georgia.
And I need to shorten it a tiny, tiny.
Ms. Rios, tell me what you're hoping happens today.
Señora Ríos, dígame por favor qué es lo que usted está pidiendo para hoy.
Yes, Your Honor, I'm hoping that we can reduce to the lowest bond possible. Not sure that he can't afford hardly anything, maybe $100 possibly. He is, oh, should I wait for you to translate?
Entonces estoy pidiendo que le rebaje la fianza lo más mínimo posible. Él casi no puede pagar nada. Estaba esperando que se lo pudiera rebajar inclusive hasta un mínimo de $100.
Ah, sí, fe.
This is the interpreter. Did somebody say something?
That's your client. Can you say that again?
I didn't see him say.
Oh, did
He
he?
wasn't talking. I don't know who was talking.
Oh, yeah, sorry. I think we had a cell phone that was on. I just cut that off. Okay.
Yeah, so Mr. Mateo Gambia Mateus is 31 years old. He has been in he lived in Sandy Springs for the last 4 years. He's from Colombia. He was doing roofing work. He has an immigration hold, and since November, I've been trying to reach out to the state to work this case out.
You are banished from the state of Georgia.
I feel really bad because I've been coming to see him, and he's just like, I just want to take a plea. I want to work this out. So I've been trying to do that, but I haven't had any luck.
Okay, I'm going to pause you because the translator has a lot to say.
Entonces el señor tiene 31 años, está viviendo en Sandy Springs, hace 4 años que está aquí, que vive aquí, trabaja aquí, es originalmente de Colombia, estaba trabajando haciendo techos, trabajaba en roofing, sí tiene una orden de detención de inmigración. Desde noviembre que yo he estado tratando de negociar con la fiscalía, me siento muy mal porque no he podido conseguir ninguna oferta para resolver este caso. He estado tratando y yo lo voy a ver al señor y me dice, yo necesito salir de aquí, si me hacen una oferta yo me declaro culpable, lo que sea, pero una fianza, pero yo necesito salir de aquí y no he podido negociar con la fiscal todavía.
Was there more you wanted to add, Ms. Rios?
¿Quiere agregar algo, señora Ríos?
Not at this time, Your Honor. Just asking for the lowest bond possible, and hopefully soon we can have a resolution. I know it's been talking with the state right now. They're trying to get someone, reach out to someone that has the authority to resolve this case and talk to the victim. Hopefully the ball can get rolling now that this has been brought, now that we're having a bond hearing and everyone is aware.
Okay, before we transition to the state, I'll let this be translated.
Entonces, he estado negociando con la fiscalía. Lo que más quiero es que le rebajen la fianza o que me hagan una oferta para resolver este caso. Quisiera que la persona que tenga la autoridad para rebajarle la fianza nos ayudara a resolver esto, que hablaran con la víctima, que movieran el caso, que hicieran lo necesario para poder resolver esto, ya sea con una oferta que el señor puede aceptar o con una fianza.
Thank you, Josh.
Did you follow all that, Señor Gamba Mateus?
El señor Gamba Mateos, ¿usted entendió todo eso? ¿Está siguiendo el hilo de lo que está pidiendo su abogado?
Thank you. We have someone with some authority here.
Judge, I'm not sure I have the authority on the reduction. However, I do have the updates.
Okay.
Entonces ya tenemos a alguien con cierta autoridad aquí. El señor fiscal dice, bueno, yo no sé si tengo toda la autoridad, pero sí le tengo algunas actualizaciones acerca del caso.
And I don't know that when you say reduction as in bond or as in charges, because I don't know that anyone was asking for charge reductions.
That was based upon Ms. Rios. I was interpreting Ms. Rios discussing about potential resolutions and moving things along based upon the offline conversation that we've been having.
Okay.
Entonces, cuando usted dice de reducir, ¿usted se refiere a reducir la fianza o reducir de una vez los cargos? El fiscal dice, no, o sea, ella en esta audiencia no pidió oficialmente una reducción de cargos, pero basado en las conversaciones que mi oficina ha tenido con la señora Ríos hasta ahora, yo entiendo que ella está buscando más bien.
Hold on. We might have a little case. Remember our ice fishing court? Remember that? Well,
94 FH. This time and date set for competency hearing. Defendant is present, represented by
competency
Attorney Andrew R. Lockyer. The people are represented by prosecuting attorney Timothy J. Rakowski. The court is in receipt, which the court did not read, Apparently, a competency report has been filed in this matter. Who wishes to speak regarding that at this time?
Your Honor, we would ask that that be marked as an exhibit and enter it into evidence.
Mr. Lockett, your position, please.
I take no position.
Okay.
Let's turn that up a little bit. This is the ice fishing court, if you remember that one.
People's one is admitted.
We have no further proofs than that report, Your Honor.
Thank you. Mr. Lockett, do you wish to present any proofs relative to that? Very well, thank you. The court will review people's one.
Add 3 more sneezes to the count. What's the cool down message for? It should say something about the devil may go down to Georgia, but you can't. I think is what it's supposed to say. Is it working? Do we break it?
You are banished from the state of Georgia.
Okay, push it again now. Do it again. You have to be lower. I think it's capital GA. There it is. All right. That's the. I'll change it to say the devil may go down to Georgia, but you can't. How about that?
Remember in the beginning when we started 110 years ago?
Is there a comma in there, red pen? The devil may go down to Georgia, comma, but you can't. There it is. There's the comma. Apply. Done. Fixed it. And now I also need to shorten up that little clip just a tiny bit. So give me a second.
Hello. Hello, hello.
All right, try it again. See if that works.
You are banished from the state of Georgia.
There you go. I cut a little clip off at the end, so it's good. I've got it as a capital GA. I'm not sure which one. I guess both still work. I guess it's not case sensitive.
It's not your turn to talk.
Josh, thank you very much for this massive super chat, which I totally got bribed into getting. That's why he said if I make that clip and dedicate it to him, being from Georgia himself.
You're comparing apples and orangutans here.
Then he would send a $50 super chat. So thank you, Josh. You bought my actions. What is this case about? I don't know. It's a little hearing. We've seen some crazy things happen in this court. The ice fishing court, for one, some of the spiciest body cam we've ever watched happen in this court. And now this is a competency hearing. Not sure who for. Actually, I can tell you who it's for. It's for Joseph William Pierce. So, and I can catch up because I'm on the rewatch. So let's
actually receive.
There we go.
The court has had the opportunity to review Plaintiff People's Exhibit Number 1. This is a report from the Center for Forensic Psychiatry. The report is dated, actually received by the court February 3, but dated January 29, 2026. The report was authored 17 pages by Dr. Jennifer Whitmore, PhD, licensed psychologist, consulting forensic examiner. In the report, and I'm quoting, based upon these observations, which I read earlier, is my opinion that Mr. Pierce has the capacities to understand the nature and object of proceedings against him, and to assist in his defense in a rational manner, if he chooses to do so. Thus, it is my opinion Mr. Pierce can presently be considered competent to stand trial. As a result of that report, and the only report from the court that you can consider in this matter relative to competency, the court finds that it's hereby ordered the defendant is competent to stand trial. This case shall continue to the next stage of the criminal process. And relative to future court dates, there was discussion in chambers regarding dates for the trial. It's my understanding that the attorneys will be speaking with court staff to schedule a date here for trial sometime next week. Is that a fair assessment, Mr. Pickles?
It is, Your Honor.
And Mr. Black?
I agree.
Very well. Thank you.
Does the court wish us to prepare the order?
Please. Does that mean scale one MC 205?
Yes, sir.
Thank you, everyone. That'll be all.
All right. Not a spicy hearing. Apparently, competency came back as a yes, and so he's going to have a trial next week. We're going to be in the Corey Richens trial, which starts on Monday. I am anxiously awaiting just the final confirmation of a URL I need for that court. So I might reach out and yank the chain a little bit, make sure that comes through. It's supposed to be here today. All right. It's 3:00 on a Friday. We should be in party mode, huh? Let's turn the lights on. Party mode. Let's see. I think that's it. I don't think we have anything else. Let's do a quick check of everybody. Judge McBurney's still doing his translation one. Let's see. Ooh, 13th. We've got Kansas up. Let's try there.
Have any questions?
No, sir.
Anything further, Mr. Baca?
Nothing further from the state, Your Honor.
There being nothing further, court is in recess. Mr. Swift, you're free to go. Have a good day.
Yes, sir. You too.
This is 13th Judicial District. First appearances on this one.
Okay. Mr. Patterson, I've got Mr. Pierce's case here. And I think that we'll be back to the jail in just a moment, but we'll take Free Walker next. State of Kansas versus Stephen Paul Pierce, 26 CR 29, state by Mr. Baca, defended in person by Mr. Patterson. Matter does regularly come before the court.
We're going to jump
and Mr.
to a different Kansas court.
Reading?
I'd be cooking.
We've got Mr. Aguirre. I'm going to join you, Judge, if that's okay. I'll just sit up here on the bench.
Okay, Mr. Bannon, I'm ready to pronounce sentence.
Okay.
In regards to count one, Mr. Aguirre is correct. I generally don't, on a first conviction for expired tag, I don't generally impose a jail sentence. I'm going to impose a $50 fine. In count number two, I'm going to impose a $300 fine. That is mandatory minimum. I'm going to order a jail sentence of 120 days. You will get credit for the time you've served on this case. This case will be consecutive to other cases that you already may have a sentence on. I don't know that you do or not. Do you?
No, I don't have any
Okay.
other.
I will place you on non-reporting probation. I'm going to assess court costs to you, which on a traffic case are $108. So if I'm adding this up correctly, that comes up to $458. How long will it take you to get that paid?
I could pay it today.
You've got the means to pay $458 today?
Yes.
I sold my commissary. Well, how did you?
All right. I'm going to place you on non-reporting probation for a period of 1 year. Since you're telling me you have the means to pay that today, I'm going to give you 30 days to pay it. So I will permit you to be released today, but a condition of your non-reporting probation is one, no law violations, and that includes traffic misdemeanors. And two, you are to pay that within 30 days.
Yes, sir.
Is he on jail on a
If you
traffic
fail to
thing?
do that, if you have a new charge or
question?
you're convicted of something else, that would be grounds to revoke your probation. Please understand, when I impose a sentence, I typically, my position is if somebody comes back and they haven't done what they're supposed to do, I just kind of accept it as they're telling me they'd rather do their time as opposed to, do the things that they were ordered on probation. So I frequently accommodate them and and since you have 120 days minus whatever you've already served, I would consider that a fairly significant amount of time.
It's Judge Fleischer.
Yes, sir.
Judge Fleischer.
So I'm going to, so you have 30 days from today to get this all paid in full. I'm authorizing you to be released following this hearing, processed out, and no law violations. So
Yes,
any
sir.
questions about those?
No, sir.
Mr. Regier, any questions?
Nothing further from the state, Your Honor.
Very well. Good luck to you, Mr. Bannon. This matter is adjourned and the parties are free to go. All right.
Judge Fleischer took down his YouTube page.
Lanaya
Doesn't
Randall,
stream anymore.
present.
And there are mixed messages about whether he does allow streaming. Some
I
people
have her
say
here at Court Security 3.
He's given
Thank
permission.
you. We'll take her up.
Some people say Judge Fleischer's given permission to people to stream, but the channels, the access channels, say he does not. And we just haven't. We'd have to get it through a website. It's still out there. People still get it. But let's listen a little bit.
All right.
more.
This is State of Kansas versus Lanaya Randall. Did I pronounce that correctly?
Yes.
Okay. Would counsel, the case number is 25 TR 560. Counsel state their appearances, please.
Jared Regier on behalf of the state.
And as you noted, you are Lanaya Randall. Ms. Randall, in looking at the court notes, it appears that you were before Judge Rickey on February the 6th. And at that point, you hadn't raised bond. But you advised that you would be looking into retaining counsel. Have you retained an attorney?
No.
How is it you're wanting to proceed with this case today?
Wait, so is this still about the insurance, the car insurance? Because I remember like I ended up getting a warrant for no car insurance or not appearing to court, and I turned myself in and I went to jail for it, and I had a bond, but I still had to come here for court. So is this for the previous ticket, like for the no car insurance? I'm kind of like confused.
You are here on the charge of operating vehicle without liability insurance, and also operating vehicle without registration or expired registration. Those are the charges against you. Those, additionally, yes, there looks like there had been 2 warrants at various times issued. One in June of 25 when you failed to appear, and then again when you missed court on December the 3rd of 2025. And Judge Webster issued so you would have posted a bond and then failed to appear. It would. So yes, today you were supposed to address as to how you wanted to proceed with the case. You told Judge Rickey you were going to retain counsel. So how are you going to proceed with this case at this time? Are you going to hire an attorney?
If I have to, yeah. I just didn't know it would I would need one for. That was the whole thing. I knew I was gonna I know I have to get car insurance and stuff like that, but other than that, I didn't know why I would need an attorney. If I need to get one, I would.
Ms. Randall, you mentioned getting a ticket then if you got the insurance things, then this all just goes away. That's not how it works. you're charged with violating these are criminal events, misdemeanor, criminal traffic matters. As you explained to you before, the no insurance is punishable up to 6 months in the county jail and a mandatory minimum fine of $300 and a maximum fine of up to $1,000. So, that's a very significant charge. The other charge can be up to 30 days in the county jail and a fine not to exceed $500. So, have you been to court before on other matters with an attorney or not?
No, I haven't been to court. I've been to court before. It was a while ago, but I didn't have no attorney with me. I just went in by myself. But
well, and some things people do that for, and that you have the right to represent yourself, but just because a person has the right to represent themselves may not be their best way of looking to it. If you wish to have an attorney but cannot afford an attorney, you can apply to the court. If you meet the financial guidelines, I would appoint an attorney to represent you. But, sometimes when people say, well, do I need a lawyer? They're really asking them, am I going to go to jail? And judges aren't allowed to say that in advance. The next thing that we're going to be determining is how you're wishing to plead, guilty, not guilty, or no contest. If you want a trial, either to the court or if you file a written request, you could have a jury trial. But we can't just stay on here and say, show up again and say, well, I don't know what I want to do.
Well, as far as the attorney, I feel like I would have to speak to my mom about that for us to get into that to see what we can do as far as an attorney. So you guys wouldn't have to give me one. But as far as
here's what I'm going to do. Jen, when's Judge Webster's next bench trial date that would be available?
One moment, I am looking
March
right now.
15th.
The next bench trial date looks like it's going to be for April 29th.
And is that a 9 o'clock docket or
That's bench trial 1:30 on a Wednesday.
Okay. Does she have a pretrial or another docket for pretrials and so forth before that date?
Not for bench trials, Your Honor.
Okay, Ms. Randall, I'm going to set your trial for April the 29th at 1:30.
Okay.
If you're going to hire an attorney or apply for one, you need to do so before the end of March.
Okay.
So, that gives you a little over a month to make your decisions how you wish to do. You are to appear where you're at today, which is at court security for that trial. Now, if you don't hire an attorney and you don't apply for one, don't expect an attorney to be appointed to you that day. That's set for trial. So that's a very important date in regards to it. If you're going to apply to the court for an attorney, you can do that. And if you decide not to, that you're going to hire your own lawyer, you're free to do that. But if you're going to apply for one, there at the courthouse, there should be applications. You can get that and fill it out and submit it. If you meet the criteria, an attorney will be appointed to represent you. Generally, that's Mr. Patterson. So, but you'll need to contact the clerk's office again and see if it was approved and who the attorney is again. And then it'll be your responsibility to contact the attorney.
Okay.
Any questions about any of that?
No.
So your next appearance date is April the 29th at 1:30. and you have to appear there at the courthouse like you're doing today.
Okay.
Okay?
Yeah.
Any other questions?
Far as in the insurance,
Well,
besides
don't say anything that might hurt your case.
Okay.
Today we're not deciding if you're guilty or not guilty. Okay?
I just need an attorney present to
Huh?
help. I just would need an attorney present to help.
Well,
case?
if you're going to speak with an attorney, you need to do that before you make statements about what happened. Okay?
Okay. Yeah.
So, and if you're not going to hire an attorney or ask the court to appoint one, then you need prepared for trial on that date. So, okay. Counsel, anything further at this time?
Your Honor, if the if the court is continuing the bond in this case, the state has nothing further other than note on the record that the state will be objecting to any additional continuances. The ticket in this matter appears to have been written, alleged to stop occurring approximately 1 year prior. We will be well past the 1 year anniversary by the bench trial date established by the court, and this is a case that has had multiple failures to appear, and the state is eager to reach a timely resolution in this matter.
Okay. I am going to continue the bond as the defendant appears today. Ms. Randall. Now, what Mr. Regier was saying is they want to do the trial that day, and if you show up or don't show up, what's likely to occur is a warrant to be issued, and you're probably going to stay in jail until your case is resolved altogether. Okay? So,
even if I do show up?
well, ma'am, if you show up and you're not ready to proceed, you can ask for a continuance, but Mr. Regier has just put you on notice. They're going to oppose that because they're going to have to subpoena their witnesses and be ready to go. So I would, and it's not on my docket. If you're on my docket, I would expect you to be ready to proceed with trial, either with an attorney or without. You've been given more than enough time and notices to get this case resolved. And so at some point in time, it's got to be decided. You can't just always put it off and say, well, I don't know yet. You need to make the decision how you're going to proceed. And if you're not willing to make a decision, then, you'll be there at a trial with no attorney and, trying to do it yourself, which for most people is difficult.
Yeah, I understand.
Okay. All right.
Yep.
So that that date is April the 29th at 1:30. Bond is continued. Now you have to physically be where you're at today. Okay.
Yeah.
All right. With that, this matter is adjourned. The parties are free to go.
Thank you.
Mr. Patterson, are you ready to proceed now on your matters?
Judge, I can proceed. I was going to ask the court if we could take up Jennifer Hart first.
Yes. This is State of Kansas versus Jennifer Hart, case number 24 TR 1842. Counsel state their appearances, please.
Jared Regier on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Jennifer Hart. Ms. Hart does appear via Zoom from a separate location. Judge, this is a case where it's a probation violation, warrant to show cause hearing. She had her first appearance on February 13, 7 days ago. During the last 5 days of working days, I have not been in a position to talk to her about her case or even look into it very closely, so that I am requesting the court to allow at least a 2-week continuance or to your next docket so that I can have time to talk with Ms. Hart about her case and determine how best to proceed.
Okay. Mr. Regier?
Your Honor, if the court is prepared to continue the bond in this case, as well as order that the defendant shall appear in person for all future proceedings, the state has no objection to setting this matter over at the defense's request. State's information is that prior to reaching sentencing disposition in this matter, the defendant had failed to appear on 2 separate occasions, at least in December of 2024 and June of 2025. Additionally, the allegations in the request for revocation, while the state does acknowledge to be mere allegations at this point, appear to allege failures to appear on at least 6 separate occasions. So the state does respectfully submit that in order that the defendant shall appear in person for all future proceedings is appropriate under the circumstances.
Mr. Patterson, how much time of a continuance are you requesting?
To your next docket, Judge.
That's March 6th.
Let me, if I could look at that date real quick just to make sure. Judge, I apologize. Can I use the March 20 instead? March 6th, I'll be in the same position of not being, I'll be in all these different courts at one time on March 6th.
And I'm not sure I'm going to be available on March 20th. So that would put that, it looks like April 3rd. Is that a holiday? And the calendar I'm looking at is it's in red, so.
I don't know.
I'm looking right now, Your Honor.
That's Good Friday, which I don't believe is a legal holiday where we don't have court.
That is correct.
Okay.
Your Honor, I was just gonna ask you, because I heard him say that he wanted me to be there in person for the next court date.
No, you should be doing these things through Mr. Patterson, who's appointed to represent you. Okay?
Okay.
All right. I'm going to grant a continuance to April the 3rd. Ms. Hart, I am going to require that you, and that'll be at 1:30, I am going to require you be present at the courthouse for that hearing. You are here before the court on a motion to revoke your probation. So if that goes against, if you're found in violation, you could be ordered to serve the original sentence, which looks like 120 days minus whatever time you've served. So that's not an insignificant amount, I would think. And yes, my general practice on a probation revocation is to have a defendant there at the courthouse when we're doing it. So yes, you are ordered to be there at Butler County Courthouse and ready to proceed. I'd strongly recommend you be in contact with Mr. Patterson, contact his office following today's hearing, and follow their instructions so that you and he can speak well in advance of that April 3rd date.
Okay.
Counsel, anything further today?
Not from the state, Your Honor.
Judge, I just want to make sure Ms. Hart has my phone number. Do you have my office phone number, Ms. Hart?
I do not. And I'm in treatment.
Write this down, please.
Okay.
316
867 5309.
Call that number after you get off this hearing and make sure my office has all your current contact information.
Yeah, sure.
Thank you. Nothing further, Judge.
All right.
Thank you.
Thank you. That concludes the Hart case, and the parties are free to go. Mr. Patterson, looks like you've got the rest of the docket. Do you have a preference on who we take up next?
Judge, just if we just start at the top, but as we're doing this, Judge, I would just ask Mr. Regier, the summary I sent you on Mr. Michael Allison, is that agreeable?
We're going to jump.
From 9 in the morning to 12 o'clock.
And were you there working or were you there eating?
Eating.
Okay, understood. Do you have any questions, Mr. Ector, about anything anyone has said so far about you or your case?
No, man, no, sir.
The gentleman that got hit by the 2x4, that you hit with the 2x4, Mr. Watts, was he someone you knew?
Do we need to back up a little bit?
What was the beef? What were you guys arguing about?
Let's back up a little bit. I need to hear what happened here.
All right, let's turn to Mr. Ector. Mr. Ector, you okay going forward even though we're interrupting your lunch?
Yes, go ahead, sir.
Okay. Well, we're going to get on the record in your case. It's 25 SC 007492. And Mr. Ector, Ms. Wood tells me you're ready to enter a plea. Is that correct?
Yes, sir.
All right. Well, Ms. Smith, and we're going to need you to move the camera or yourself, Ms. Smith, a little bit so Mr. Ector can see you. Ms. Smith is going to put you under oath and then ask you questions about your case. You need to answer those questions truthfully and completely. You also need to let me know if you've got any questions. Will you do that?
Yes, sir.
Okay, Ms. Smith.
Mr. Ector, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
And you can lower your hand. Please state your true, correct, and legal name for the court.
Ma'am?
Please state your true, correct, and legal name for the court.
Bruce Leonard Ector.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 53 years old, and I went all the way up to the 12th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Mr. Ector, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
We're not.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 90 days with the balance probated?
Yes.
Are you aware that the court does not have to accept that recommendation and can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Are you currently on probation?
No.
And are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of both of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence and other witnesses of your own, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Ector, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 25 SC 007492, how do you plead to count 1, aggravated assault, and count 2, aggravated battery?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Ma'am?
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there's some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. Do you also understand that this has to occur within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Okay. Thank you, Mr. Ector. Your Honor, if this case were to proceed to trial, the state would show that on August 13th, 2025, officers responded to 2033 Joseph E. Boone Boulevard, that's in Fulton County. When the officers got there, they talked to the victim, Mr. Watts, who stated that the defendant, they got into a verbal argument, and the defendant picked up a 2x4 that had spikes on it and hit the victim in his face with it. At that time, Mr. Ector was not on the scene, so the officers were not able to talk to him initially. However, they were called back to the scene on October 7th, 2025, and the victim told them that the defendant was at the location at that time. The officer spoke with the defendant at that time, who was arrested for these charges and charged accordingly. And those are the facts of the case. Regarding the negotiated plea between the state and defense, we've agreed to an offer of 5 years to serve 90 days with the balance probated. As far as special conditions, the state is recommending an anger management course for the defendant to stay away from the incident location, for there to be no contact with the victim, and for the defendant to complete 30 hours of community service. And that is all from the state, Your Honor.
The indictment suggests Mr. Watts, that's the gentleman who's the victim in the case, something bad happened to his nose. Do you know how he's doing, the status of his recovery, and his thoughts about this outcome?
Yes, Your Honor. Well, no, Your Honor. We did reach out and tried to reach out to the victim. We did a victim locate. We were not able to locate the victim and ask him about his injuries.
Okay. This address on Joseph E. Boone, do you know what's there?
I'm not sure. Let me look that up. I'm not sure what's there.
Okay, while you're looking it up, let me find out from Ms. Stallworth, criminal history information on Mr. Ector.
Yes, Your Honor. Excuse me. He has 34 cycles. There are 2 FTAs, 2018 from the city of Atlanta, 2012, also from the city. There's a 2016 conviction from Clayton County for criminal trespass and terroristic threats and acts, and there are 7 convictions outside of the 10-year period. Nothing further.
What's his most recent arrest?
Give me just a minute. I think it was at 2018 from the city.
So they could like, oh, we should go. If Jane
Clayton County in 2019 for a probation violation.
Okay, and then obviously this, but between then, 2019 and this case, there were no cycles.
Give me just a moment to check make sure. That's correct.
Okay, and then you said there were 7 convictions, but they are all more than 10 years old.
Yes, 05, 03, 02, 2000, 98, 93, and 92.
Way back when. Okay, great. Thank you so much.
You're welcome.
Ms. Wood.
Back in the
Thank you,
day.
Judge. So Mr. Ector has already done the 90 days. He's actually been in 107 days. He's a lifelong resident of Atlanta. I have spoken to his aunt. He'll be living with her in the area, and he is hooked up with Tin Park Place. He gets his medication there. So we're just asking that you accept the state's recommendation in this case.
All right.
Yeah.
Yes, Ms. Smith.
What is
That location is a True Worship Fellowship Church.
Church. Thank you. Mr. Ector, were you a member of the church where this happened, or was that a place where you and Mr. Watts hung out, or what's your connection to that address?
That's the place where they feed the homeless folks at Monday through Friday from 9 in the morning to 12 o'clock.
And were you there working, or were you there eating?
Eating.
Okay, understood. Do you have any questions, Mr. Ector, about anything anyone has said so far about you or your case?
No, man, no, sir.
The gentleman that got hit by the 2x4, that you hit with the 2x4, Mr. Watts, was he someone you knew?
Yes.
What was the beef? What were you guys arguing about?
Well, the true story is that the man had hit me about 3-4 times in my face before I even hit him one time with the stick.
Okay.
I never got to tell nobody, but Your Honor, I was struck in my face to my eye was swollen and everything 3-4 times. And the dude at the church named T and the girl named T, they would tell you that he came around that curve at me again, and that's when I hit him with a stick. Cause sitting there, I would have never hit that man with no stick.
Okay, so I hear you. There's as an element of self-defense to this. What were you and Mr. Watts upset with each other about?
He thought I had got his jacket, and
okay.
I was like, the jacket that I was laying on the ground was an old beat up jacket. He thought I had not stole the jacket, and I was like, nah, I gave him the jacket. Here, man, get the jacket back. I don't want none of it. That needs you on.
Mr. Ector, when you get out, you're going to get out soon. You'll get out early next week, probably. Are you going to be able to go to a different place for meals? Because you really can't go back to this church anymore.
Listen, I know I'm not going back to that church no more, period.
Okay.
Even from that, I ain't even trying to see him. I don't want to see him because he gonna hit the crazy move again.
Okay. Well, it sounds like you've got a good plan in place. Mr. Ector, I find there's a factual basis for your plea, and that your plea is what we call knowing and voluntary, meaning you've understood what we've been talking about, and that you've decided that taking this plea is the right thing for you to do. Is that a fair statement?
Yes, sir.
All right, then I'll accept your plea. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith?
Yes, Judge.
And Mr. Ector, can someone in my office sign the indictment for you? Just indicating your guilty plea. Is that okay if we do that?
Yes.
Okay. I'm going to sentence you on count 1 to 5 years to serve 3 months with the balance on probation. Count 2 is going to be that same sentence. So it's a total of 3 months in custody, followed by 4 years and 9 months on probation. Special condition of probation number 1 is you stay away from the church on Joseph E. Boone. Even though they were good to you, you got to go to a different place for meals.
Okay.
Special condition number 2 is you stay away from Mr. Watts.
Okay.
I'm going to ask that the folks with probation help you find an anger management class. And you're going to do 30 hours of community service. And you need to do those in the first 6 months of your probation.
Okay.
I'm going to ask that probation assign you a mental health probation officer, someone who's going to help you coordinate with 10 Park Place and do the things you know you want to do in connection with that. And I'm going to set a behavioral incentive date of February 21st, 2029. And what that means is that if you've done well for the first 3 years of your probation, no issues, no arrests, no hitting someone with a 2x4, then we can end this early and you can be going about your business without probation in the mix.
Okay. Thank you, sir.
Well, you're welcome. Any questions about that?
No, sir.
Ms. Wood, anything else on behalf of Mr. Ector?
No, Your Honor, thank you.
Ms. Smith, on behalf of the state?
Yes, Your Honor.
Yes, sir.
Can I ask you one thing?
You may.
I want to know, I'm just asking because I'm still kind of lost with what you're saying.
How much what is going to be?
No, I ain't asking on how much then it's going to be. I want to know when I'll be released.
Oh, you should get out Monday or Tuesday.
Okay.
Because you have already done 3 months. I sentenced you to give you credit for the time you've done. But hey, don't run away quite yet. Ms. Simpson, do you need to give Mr. Ector some reporting instructions?
Yes, Judge. Mr. Ector, you need to report.
Whoops, I hit the wrong button and I muted you. It's not personal. I was trying to get you big on the screen. There you go. If you would unmute yourself. All two of you. There you go.
Can you hear me?
Yep.
She has her profile picture as her
Mr.
background.
Ector, you need to report to the Atlanta Probation Office. That is 276 Memorial Drive. That's about 5 minutes from where you are. You need to report there within the first 2 days after you get out.
Look, you said that out Memorial Drive or Memorial?
It's 276 Memorial Drive.
That's in Decatur.
Nope. It's right here downtown. Mr. Ector's not here in court, so it's actually pretty far from the jail, but it's about 2 blocks from the courthouse, right downtown. Like if you get to the, where the Greyhound bus station is and places like that, they're all about 2 blocks from each other.
Okay. Well, thank you.
No problem.
Okay.
Nothing further, Judge.
All right. Thanks, everyone. Mr. Ector, you're good to go. You'll get out Monday or Tuesday, okay?
Okay.
Bye-bye.
Why Monday or Tuesday? If he served his time, let him out.
All right. We need to knock out AC/DC.
There's a soundbite.
And that is...
Oh, never mind.
Mr. Richardson, Judge.
Yep. And that's Ms. Wood and Ms. Smith. So we got everyone we need.
Does he have glitter
All
on
right.
his hair?
What are we doing, Ms. Wood? I'll get us on the record in a moment. What are we doing with Mr. Richardson?
Non-negotiated stipulation.
Okay. Let's get on the record. This is position 12, State versus Orion Richardson, 25 SC 004592. And Mr. Richardson, I've got your warrant right here. I signed a warrant for your arrest in connection with probation in October of last year. And the allegation is that after you pled, you were released. You were told to report to the office within 48 hours. You may have heard Ms. Simpson just tell Mr. Ector that. And you didn't, and no one could find you. So you've done what we call absconding. You were supposed to plug in with probation as the first step of your sentence, and you didn't. You've now been sitting in jail for a while, and we're going to work through that. Ms. Wood is...
I've emailed you an updated petition.
Oh, it gets interesting. Let's see. Here we go. Oh, does Ms. Wood know about the updated petition?
Yes, Judge.
Okay. So not only did you not appear, but you got arrested for new charges: theft by receiving, stolen property. Oh, goodness. You were sounds like maybe driving someone else's car real dangerously, and you didn't report. That's now kind of a small deal in light of the big deal of all this other stuff. So, Ms. Wood, now that I understand more, what's the status of these charges?
It's unindicted, Judge.
Okay, thank you. So Ms. Wood, is Mr. Richardson stipulating to the arrest?
Yes, Judge, stipulating to the arrest only.
Okay, is he denying that he failed to report or he couldn't report because he got locked up?
Yeah, yes, so I'm sorry. Stipulating to the new arrest and then also to the technical violation as well, Judge.
Okay, well, tell me your recommendation, what's going on with Mr. Richardson, and then I'll hear from Ms. Smith.
Your Honor, Mr. Richardson is 36 years old. He's a lifelong resident of Atlanta. There was a short turnaround between his release from the original case and this arrest, so he had not yet gotten back on his feet, so he was unemployed at the time. He does have a good, stable address on file with probation. He's asking the court to consider revoking 4 months. He's been in 127 days and then reinstate to probation.
All right, let me see. He's got a little less than 3.5 years remaining on his sentence that he had just started. Okay, Ms. Smith.
Yes, Sharon, in this case, the state will be asking to revoke 18 months and to reinstate the balance, mostly because the new offense happened just a month after he took the plea for the underlying charge, and also that those new charges are very similar to the underlying charges he took the plea for. For example, theft by receiving, fleeing and eluding, and reckless driving are 3 of the new charges that are the same as the one that he already pled guilty to. So because of his high risk of reoffending, the state would ask for, or the fact that he reoffended just a month after taking the plea, the state is going to be asking to revoke 18 months and to reinstate the balance in this case.
Okay. Ms. Simpson, does the Department of Community Supervision have a third view?
Judge, I conveyed to Ms. Smith as well as Ms. Wood that my recommendation would be to revoke a year and to reinstate. However, I would also take in consideration a drug court referral.
Okay, and tell me what's behind the drug court referral.
Given that, as Ms. Smith stated, the new charges are pretty much replicated of the current charges he's already on probation for. I just thought that it would, if we could kind of jump ahead of the possibility of him reoffending by taking care of some substance abuse issues, that would, the hope is that it would kind of help resolve the reoffending part.
Got it. Okay. All right. Ms. Wood, anything you want to say in closing?
No, Your Honor.
Okay. Mr. Richardson, anything you want to add?
I was just, yes, sir. Well, when I came here, it's a long story. I don't want to talk about it. But the judge at preliminary gave me a signature bond. And he gave me a signature bond for the charges. We discussed, and he was basically saying that, you know, being that I had no FTAs and that he understood my situation, that they should reinstate my probation. I get another chance. And then he was saying this will be my last chance. That's why they gave me the signature bond on my first. Because initially, yes, it was a technical violation initially. I did report 2 times when I went up there. Went up there to do the intake. My initial officer, the initial probation officer, was not there. Judge McBurney. Then I had to come back again until they gave me a date to come back for the it was I was supposed to I wasn't actually supposed to be there because it was referring to community service. So they had my paperwork messed up, and then after that they gave me a later date, and then that's when this actually occurred. So when this occurred and I went to court, this is what the judge was basically discussing with me, saying that the judge or whoever was referring to you, that I should get another chance, and this will be my last chance. That's why they gave me the signature bond for my charges. I received a signature bond October 21st for my charges. So he was like, okay, well, when you go to probation revocation, do that petition. The first petition was the technical violation. And on the run, I caught the new charges. He said the judge, he was just saying that the judge should possibly recommend, reinstating probation, and this would be my last chance. If I mess up,
Okay, well, that's not quite what's in the records. In October, you were in front of Judge Oliver, and she set a $37,000 bond. For a few of the counts, it was UJR, but the total bond was $37,000. Then you waived your preliminary hearing, and in November, Judge Kura lowered your bond to $28,000. So there are pieces of it that are signature. You were able to sign for driving without a license, but for the stolen car, the damage to property, the reckless drive. In fact, the reckless driving is a $10,000 bond. So they lit you up, and I understand why, because you got those charges so soon after pleading to very similar charges. Now, I'm not trying to contradict whatever you think those judges said to you. You were there, I wasn't, but the paperwork doesn't quite bear out what you were sharing with me. But in some ways, it doesn't matter. We don't need to go around and around on that, because those judges were fulfilling a different role, and they set a bond. And I'm the one who sentenced you not all that long ago, and you said, Judge, I'm gonna be a different guy. And just a few weeks later, we had almost the same thing happen, which is dangerous to you. It's dangerous to everyone else on the road, as you are trying not to get caught by the police who are simply trying to pull you over. So, given your stipulation to the new charges, I am going to revoke 12 months or 1 year of your probation, reinstate the balance. If in the interim, your lawyer and the prosecutor can come to some agreement and want to get the case accused, I'm happy to have it green sheeted to me, since I've heard about it. But otherwise, those charges will go in whatever direction they go. And we'll see what happens. But the judge who gets that case will obviously know that you have already had some consequences for the new arrest in terms of what happened with the revocation. I'm open to drug court. I don't know that it's necessarily something that fits for you, that not what shows up in any of the charges, but we can revisit that at the appropriate time. Ms. Smith, yes, Mr. Richardson?
So you revoke a year, so the case will be, what does that mean? The case will be over with, as far as, like, what does that mean? I gotta go to prison or county time?
So I'll break that down into two things. So your older case, it's not very old, but your older case, the one you already pled to, I just revoked a year of your probation. So you're going to do a year. You will go into state custody because that revocation is more than 6 months. And your new charges, I suspect, will turn into an indictment during the course of that year. So it'll be assigned to a judge, and that judge is going to learn from your lawyer, hey, Mr. Richardson's in custody. They'll try to connect you via Zoom from wherever you are, and you may well be able to resolve these new charges while you are working on your revocation in these slightly older, very similar charges. Did that answer your question?
Yeah, so basically what you're saying is, while I'm locked up in prison, down the road, the new charges, I go to court from while I'm in state custody, and y'all will work that out and resolving new charges.
Right, but you of course will be in the mix. Your lawyer will reach out to you, and your lawyer will give you her advice. Hey, you know what? You should just appear virtually. You could insist on, I want to be there in person. They could get you on the van and bring you back up here. Very few people choose to do that because you can get plugged in with resources and programs, and I come back to Rice Street. But you and your lawyer will talk about where you will be while you are working on the new charges. But I suspect the new charges will be indicted, and you'll get assigned to a judge, and you'll get a lawyer while you are dealing with this revocation. And you could choose to work it out if you think it's a fair outcome while you are down in DOC, so you don't have to come back to Rice Street or ACDC to deal with the new charges. But that's your call. No one forces it on you. You and your lawyer will talk about that.
Okay, so do I get accredited for all the days that I've been in here since October 7th? get credit for all the days?
You're not going to get credit for that. That's why I didn't revoke 18 months. So I revoked less than what the state recommended because in my mind, I'm thinking 18 months isn't a bad recommendation, but I can't give you credit for time served. So I just need to shrink the amount of the revocation. So instead of revoking 18 months, and then you would not get credit, I revoked less than 18 months, knowing that you had already done a little more than 3 months. So what you could view it is that I revoked 15 months. But I don't want to say that because if I revoke 15 months on, I just said it, but that's not what your order is going to show because you wouldn't get credit for the 3 you did. So I backed the 3 out and I'm revoking it for 12 months. Okay?
Okay.
All right. Ms. Wood, anything else?
No, Judge, thank you.
You're welcome. Ms. Smith, anything else?
No, Judge.
All right. Good luck, Mr. Richardson.
All right, waiting to get on the bus then, right?
Say that.
Waiting for the bus then, the Bluebird.
You are waiting on the bus. Exactly.
All right.
All right. Take care.
All right.
He has places to go and vehicles to drive when he gets there, apparently. GTA 5, reincarnate. All right, that's going to take us all the way to 3:47. We're going to wrap it up today. I'm getting a little sleepy. I'm tired. I'm trying to save my energy for Monday, where Corey Richens begins. Super excited for that one. So I'm just, it's going to be amazing. It's going to be amazing. Let's see. Check the email box one more time. Let's see. It's not here yet. Grr. I would have come to that email. But I got an email from Sweetwater, which is almost as good. All right. Thanks all for being here. It's been a quiet afternoon. Sort of fun. Sort of low-key kickback. Thanks to the amazing mods who keep everything going and copacetic. And thanks to all of y'all for being here and being part of this amazing community on YouTube, for making it possible for me to do what we do every day. It's amazing. Josh, thanks for the massive super chat, and stay out of Georgia. So, I am feeling much better. I'll be back to 100% by Monday. So that's good.
You are banished from the state of Georgia.
There you go. There you go. There's Judge McBurney. Might be a first audio clip we have from him. So tonight when you go home,
beginning when we started 110 years ago.
Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe. We go live again Monday morning. We'll be live at 9:30. Court will start at 10:30 Eastern Time, 8:30 Mountain Time. Corey Richens, 5 weeks of trial, and we're there for every minute of it. All right. Love you guys. Have a great weekend. Stay safe. Whatever you do, send pictures to the burner phone. I'm supposed to show you a picture, actually. I'm supposed to show you. Is it this one? This is Greeners and Josh. Apparently, it's disco night this weekend, and they're going to go and hit the dance floor with the bell bottoms. So it's going to look great. You guys have fun. All right. You guys be good to each other. Love you all. Have a good one.
You are banished from the state of Georgia.